it's Lori Brown from yournurseattorney.com, nurse attorney, coming at you today to answer the question about what happens if I have a criminal matter. Now, unfortunately, if you do have a criminal matter, it can affect your professional license. So it's very important to be proactive and to have your criminal defense attorney understand the laws that can impact your license as a healthcare provider. Now, your criminal attorney may do an awesome job at keeping you out of jail, but if you can't go to work after that, what good is that? So I always say protect your freedom first, but then protect your license so that you do have something to go back to work for. So unfortunately, there was an attorney who thought he was doing a wonderful job for his client. The client was accused of, we'll call her Ellen. She was accused of stealing narcotics from a hospital. And her attorney, let's call him David, said, I'll represent you, I'm a criminal defense attorney, and he wound up making a fantastic plea agreement for her. Basically what happened is she was allowed to go into drug court for a year, and if she doesn't have any problems with the drug court, then the felony would be erased, which sounds fantastic, doesn't it? However, the Office of the Inspector General, they're the arm of like Medicare and Medicaid, or the Secretary of Health and Human Services, designed to prevent fraud and abuse against Medicare and Medicaid patients. So if there's any concern that the nurse was taking medication from a Medicare or Medicaid patient, or was billing Medicare or Medicaid for services that were not actually provided, like for the medications, then they're going to put you on what's called an exclusion list. Now, the Office of the Inspector General has an exclusion list, and there's two types of ways to get on the list. The first is mandatory, and the second is permissive. If you are convicted of a felony, and a conviction even includes going to drug court, or a diversion program, or pretrial agreement, any of those things are considered a conviction. So if you are convicted of a felony of anything that would be considered taking drugs from a patient, such as patient abuse and neglect, felony convictions or other healthcare related fraud, theft or other financial conduct, or felony convictions related to unlawful manufacture, distribution, prescription, or dispensing of controlled substances. All of those can place you on the mandatory exclusion list. Now here's the thing, the mandatory exclusion list means that you're on there and it's mandatory. There's no way to get you off of there. And what the ramifications are is that you cannot take care of Medicare or Medicaid patients for the next 5 years. So even if your conviction is erased, like with the drug court situation, after a year, you are still on that list for 5 years. And it doesn't come off automatically. You have to ask them to take you off the list. Now, with permissive exclusion, that includes misdemeanor convictions related to healthcare fraud other than Medicare or a state, relating to healthcare fraud other than a Medicare or a state health program, misdemeanor convictions related to unlawful manufacture, distribution, prescription of controlled substances, suspension, revocation, or surrender of a license to provide healthcare for reasons bearing on professional competence, professional performance, or financial integrity, provision of unnecessary or substandard services, or defaulting on a health education loan or scholarship obligations. So here what this is telling us is that if you do surrender your license in another state, you could wind up on this list if it has to do with professional competence or professional performance, even if you have a license in another state. And once you get on this list, again, if it's mandatory, there's no way to get off of it. If it's permissive, you're going to have to fight it and show why you shouldn't be on the list. But the best way is to not be there in the first place. There's also state statutes which your criminal attorney needs to look into, such as all facilities normally do a background check, especially nursing homes. And there's certain convictions that if they're on your background check, you won't be able to get a job in a nursing home. So let me give you some examples. In Indiana, if you're convicted of a sex crime, exploitation of an endangered adult, failure to report battery, neglect, or exploitation of an endangered adult, theft if the person's conviction for theft occurred less than 5 years before the individual's employment application date, murder, voluntary manslaughter, involuntary manslaughter within the previous 5 years, felony battery, or felony offenses relating to controlled substances within the previous 5 years. So you would think that that these are difficult to get, but you would be surprised. A sex crime can even mean like inappropriate conversation with a minor. They could be considered a sex crime, and I'm talking like a 16 or 17-year-old. Sometimes they don't actually know what to charge, so they'll just pick one of these categories that works. But again, if you're in one of these categories, you can't get a job. So all the hard work that your criminal attorney has done will not necessarily protect your nursing license. So it's very important that you talk to your criminal attorney about making sure that that attorney knows the laws that can affect your professional license, so that they don't recommend that you agree to something that is going to prevent you from working. So I hope this helps, and until next time, bye for now.